It lies with President Tinubu. I hope someday, somewhere, a journalist will ask him that question. But I'll tell you what, when I see statements issuing from the villa, not in particular from Tinubu himself, from President Tinubu himself, but from his underlings, that this matter should be resolved by the courts, it gets me thinking, is someone somewhere contriving some predetermined result from the courts? What is informing this blind confidence about the matter of Mazi Nnamdi Kanu should be resolved by the courts? It begins to sound to me like someone who stole your election, and before you open your mouth, INEC tells you go to court, like a mantra. You know, it's suspicious. Why wasn't Ibuho's case resolved in the courts? Why wasn't the chairman of Miet Allah's case resolved by the courts? Why wasn't Shore's case resolved by the courts? So when they begin to insist that the matter of Mazi Nnamdi Kanu should be resolved by the courts, it takes me back to 1963, when they were also saying the same thing about the case of Obafemi Awolowo and Anthony Inahoro, charged with treasonable felony. And they were facing a trial in which they had the option of taking summary trial or the other, but they pushed them into summary trial and convicted them with a bat of an eyelid. It was a political trial. They were also saying it should be resolved by the courts. So his conviction was contrived. We learned later from Justice Show that his hands were tied. So it makes you suspicious when the executive branch that is prosecuting you leaves no room for discussion other than telling you it should be resolved by the courts. Otherwise, why do we have that provision in Nigerian Constitution that the Attorney General can discontinue a criminal prosecution? Why is it difficult to apply that to an Igbo man when that very provision had been applied to non-Igbos in recent times, including by the present administration?
All right, let's move on. The issue of Nnamdi Kanu, we had sacking all his lawyers or firing all his lawyers, and including very senior advocate of Nigeria, Kanu Agabi, and other counsels from defending him. What are the implications and what is left for him?
Well, you know, using the word firing is not, I would say, debriefing and disengaging. It's a strategic move by him. He's a well-educated man, and he has his mind intact. He's fully aware of what he's doing. That's all I can say to that.
Why do you think the Southeast governors are not championing the cause of Nnamdi Kanu's release?
It's for them to answer, and it's quite shameful that is the conclusion that has been drawn since last year, when they declared in July last year that they were going to interface with the president on the issue of Mazi Nnamdi Kanu. Nothing has been done. So they just have to explain to Ndibo why they have not taken any step visible, seen. I hear a lot of things that some of them have taken some covert steps, but I didn't see that. But I don't have any reason to doubt them. But I think what needs to be done and what needs to be convincing is something you do in the open. If Southeast governors empanel themselves or convene themselves one day and say, this weekend we are going to Villa to discuss with President Tinubu on the question of this issue of Mazi Nnamdi Kanu, I think, you know, Ndibo will be very proud of them. That hasn't happened. And to me, it's not something that to be proud of.
Looking at the strategic moves you talked about right now, what is the current status of his defense?
Mazi Nnamdi Kanu believes that he has no case to answer, that there are no charges facing him. Listen, let me tell you a story. You know, you're not lawyers, but you know that once a law is repealed, it's repealed. Can you believe that the Terrorism Prevention and Amendment Act 2013 was repealed in July 2022? Mazi Nnamdi Kanu is still being charged under that old law. which was replaced in July 2022 by Terrorism Prevention and Prohibition Act 2022. We're in 2025, and you're still trying him on an old law. Let's not talk about extraordinary rendition, because somebody might say, oh, the Supreme Court said, okay, he was rendition, but he's still subject to trial. But there are other issues dancing around that. What about the root fair hearing that was not given to him in Kenya? If Mazen Nnamdi Kanu was offered the due process of extradition in Kenya, he may not be here today, because there are a lot of defenses to extradition within the extradition laws of any nation, including Kenya. So there are just so many issues, and he was discharged in October 2023. Okay? Now, this case took like a year and a half to get reinstated. And while that was going on, in fact, even at the Court of Appeal, the law was repealed. So what is he facing before the Nigerian judiciary now? Charges based on old law. It's for the courts to decide. But these are one of the defenses in chief or cases in chief that are emanating from him, that are a challenge to his prosecution or his trial.
The judge handling the case has said he should consult very experienced lawyers to explain to him the implication of standing trial for himself, or I don't know that, or what it implies. So what is your own advice on this matter as it is now, representing himself or going to seek for more serious advice?
He has legal consultants.
So what is he likely to do now?
Now, the Kanu will not be the first person to defend himself in a criminal trial. I can give you several examples. Martin Luther King did it in America. At some point, Gandhi, the father of non-violent resistance, did it in South Africa before he escaped to India. I think Mandela tried to defend himself too at some point. And in 1963, we go back to Awolowo again. Awolowo defended himself. He was assisted by some lawyers, including one from England, who was denied entry into Nigeria, but eventually he was granted entry. So Awolowo defended himself. So a lot of defendants, people who were subjected to criminal trial, have defended themselves in history. Nnamdi Kanu will not be the first. But that does not obviate the fact that he does not need the advice of experts. If he feels he does on any question of law, I think he's wise enough, smart enough to go for it.
Let's revisit the issue of IPOB.
Yeah.
Based on your submission about the Enugu High Court, talking about that it was unjustly, the process of prescribing IPOB was not right.
Was unconstitutional.
Was unconstitutional.
Yes.
So are you likely at any point in time to challenge this particular issue, or is it part of what you are going to drag into the case at any point in time?
Well, the prosecution of IPOB is before the Supreme Court right now on appeal. And Mazen Nnamdi Kanu is being charged based on the prosecution of IPOB. There's also a question amongst legal experts. Is it right, under jurisprudence, to subject a man to trial on a law that has not become final? What criminalized the IPOB activity and put Mazen Nnamdi Kanu in detention is the notion, the court order, that IPOB is a terrorist group. The court order proscribing IPOB. That court order, a lot of Nigerians don't know, is still under appeal. Section 36 sub 12 of Nigerian Constitution says no Nigerian should be put on trial except on the basis of a written law. Let us assume that the prescription of IPOB has become a written law. It hasn't become a final written law. It's still lying before the Supreme Court. These are some of the issues that I believe the executive branch should have looked at and say to themselves, well, what's the hurry? Maybe we should let this man go, because even the prescription upon which we are prosecuting him is not even final. It's not yet final. So these are the issues, the legal issues dogging his prescription. And these things are very likely to also occur as legal arguments in court.